Right, thank you. And our next question is around an agent's claim for the sale of a property. So the basic question is, if you have a seller that's sold a property, there was an agent involved, and the seller has now done the transaction and basically pushed the agent out. In other words, they've gone and concluded a contract with the purchaser and then didn't include the agent, the agency fee, or the fact that the agent had introduced in terms of that purchase agreement. Is there any chance that the agent can pursue their claim against the purchaser in that particular transaction for their agency fees?
So the question on whether an agent can claim commission from a purchaser or even a tenant in circumstances where it's a leasing mandate, it's a very strange scenario. And unfortunately, most agents don't like the answer that I have for them. Now, if you're an estate agent, starting from the beginning, if you're an estate agent, you get a mandate to sell the property, or you get a mandate to procure a tenant for a lease, right? You get this mandate from the seller. So unless it's the purchaser that's signing this mandate with the agent, you typically are contracted to the seller. So automatically, this means that the seller is responsible or liable to pay you commission. So a seller or landlord is liable to pay you commission if you fulfill your mandate. Simple as that. Your claim lies against the seller. So in circumstances where a purchaser or a tenant decides to go behind your back, despite your hard work in introducing the property to this purchaser or tenant, they go behind your back and they try to negotiate and contract directly with the seller or the landlord, depending on the instance. If they do this, right, and the deal goes through and you don't get paid your commission, in theory, again, your claim lies against the seller or the landlord and does not lie against the purchaser or the tenant. You would have to sue them. Now, a lot of agents then come to me and say, no, but I don't want to sue them. I mean, these are my clients. A lot of sellers give me repeat business. I'm certainly not going after them. Remember that at the end of the day, if you sue the seller to pay you commission, the seller has a claim against the purchaser to pay him commission. So there's ways of doing this without necessarily leaving the seller out of pocket. So, for example, the one way is to involve all the parties in the summons and basically allowing an indemnification to take place where the purchaser will cover the commission, but it's technically a claim by the seller against the purchaser or the landlord or tenant. Or another way, for example, is the cession of rights, which we've done quite often, where the seller has ceded the rights to the agent, and the agent goes forth and actually sues the purchaser and exercises those rights without involving the seller. So there are ways of doing it. There are ways of going against the purchaser, right? Sorry, so now I'm saying suing the purchaser or the tenant. There are ways of going against them without necessarily involving the seller. Last thing to mention is I've had this debate a number of times with a number of attorneys. Is there still potentially a claim, aside from what I've mentioned, against a purchaser or a tenant if something like this happens? Unfortunately, the likeliness of a claim existing is very slim. You're probably, we've debated it a million times. I've come up with a couple of ideas, but unless your facts are perfect, and even then, we're not 100% sure, but if your facts are perfect, if the purchaser actually breached a duty that he has to this agent, which technically he doesn't, because there's no nexus between the two. And if you really acted mala fide, and if you truly cannot claim your commission against the seller, maybe, just maybe, there's a claim. But unfortunately, like I said, it's just a maybe, and no one has actually explored this to that degree. So if you're the first, you're welcome to approach us, and we're happy to do an opinion for you. But as it stands at the moment, the seller's your best bet. Speaking to the seller, getting those rights, and possibly using the seller's rights to claim against your purchaser remains the best bet, in my opinion.